Hello, welcome or welcome back to Life on the Franch. Today is our second episode of Free Speech Fridays. What a week it has been and will be next week. So today the big news story is that the Supreme Court is currently ruling on a free speech K-12 case, which they have not done in a while. It has been a long time. And what makes this case particularly interesting is it'll be the first case concerning online speech of students at the Supreme Court level. So I'm filming this at like 12:20 a.m. on Friday, April 30th. So the court has not issued their opinion yet. However, there's been plenty of articles written about the case already. So let me give you the basics of the case. Basically, the case centers around a high school girl who was on the cheerleading team. This high school cheerleader was asked to stay on the JV team for another year and was a little bit frustrated with that decision. So she was out of school on the weekend at a cafe, and she made like a little snap story on Snapchat, basically saying, and she used the full terms, I won't be using them here, but she said, quote, F school, F softball, F cheer, F everything. So this is a 14-year-old. And then the Snap story was up. Snap stories only last like 24 hours. However, it went out to 240 of her friends because it's on the story, and one of those friends happened to be the daughter of the cheerleading coach, who then saw the story and then asked her to leave the team for a year in response to the aggressiveness of the snap. So this raises the question, can you punish students for speech outside of school? Particularly speech that for all intents and purposes isn't causing any damage to anybody. This isn't a case of really cyberbullying. It's not a vendetta against a particular student. It's not going to cause like mass disruption. I can't think of anyone I know who has not at some point said something along those lines when they're frustrated, particularly about things they care about. And clearly this 14-year-old cared a lot about cheerleading. Also to mention about this case, so the student is being represented by the ACLU, in a shock that will come to no one. But it has gotten a lot of people on her side, like from across the political spectrum, because of how wide this could get if this speech is able to be censored by schools. Because basically you would be carrying the limited speech rights you have at a school all the time as a public student everywhere. This case also takes place in Pennsylvania. It's Mahoney Area High School. So that's basically the question. The question is, like, can schools regulate online speech that is off campus, that is it like not going to cause any specific damage to the school, isn't cyberbullying, and isn't like there's no one that's going to think it bears the school's imprimatur. I'll be straightforward. My position on free speech is we should have more of it, especially in schools, because we have so little, and we'll get into that in a second. And the Supreme Court justices on this case are also very concerned, because it is such a monumental case. I cannot stress this enough. This case is pivotal. It is the first case about online student speech at the Supreme Court level, and Justice Breyer said, quote, "I'm frightened to death of writing a standard," end quote. And so it's, people have been speculating, and I'm going to link all the articles down below, that the court's ruling, leaning towards ruling in favor of the student. The court is unwilling to say that they can never monitor online speech, that they are going to say they can't monitor online speech. And there are some saying, and this seems to be what I'm getting from the justices themselves, is that they're going to kind of leave the door somewhat open. But I think this is a huge mistake. So the lawyer, David D. Cole with the ACLU, said, quote, said that she was punished for, quote, merely expressing frustration with a four-letter word to her friends outside of school on a weekend, end quote. So he goes on to say, quote, "Her message may seem trivial, but for young people, the ability to voice their emotions to friends without the fear of school censorship may be the most important freedom of all," end quote. However, and I mean, I definitely agree with that. Ranting is such a part of dealing with stress. And it's very difficult now that things are just out there, even when they're for 24 hours, like kind of forever. But it's also just like, I'm not saying we should like promote swearing or anything, but swearing outside of school and like punishing someone that's not your kid for it is a little weird in today's day and age, especially with the music that kids are listening to. I say kids, I'm barely not a kid. I'm a master's student. But, with the music of today, and I swear like a sailor, and I would consider myself a professional person. I just don't see this being the time to crack down on speech rights. However, so the school district's argument is that a couple things. First, it's different to be in a sport than it is to be a student. So you could sign up to be in a sport and relinquish some of your speech rights in order to keep up team morale. This is how you have, if you're involved in extracurricular activities, they can force you to take a drug test, but if you aren't, they can't. It's the same kind of argument. However, I would argue that speech is more important than that, especially when this is not like illegal speech. Nor is it really hurting anybody. And the speech that is like, like one of their other points is, well, what if this was cyberbullying? We can't defend, like, cyberbullying happens and then it comes into the school and it affects people. Well, cyberbullying is not protected speech, it's harassment. So there is a place for it to be taken care of. It's not by the school. Not to say they couldn't do some restorative justice or something, but that speech is not protected. So there is a remedy for, like a legal remedy for students who are being harassed, that they should take if they are being cyberbullied. The same is true when pictures of students in the nude are circulated throughout the school. That would be considered harassment, if not child pornography, depending on the age of the student. So there are legal ramifications for that as well. All of those things already are not included in the umbrella of protected speech. So drawing the line here so that we can include those doesn't make any sense because they're already not protected. But how did we get here? How did we get here? So I think to really get a handle on this case, because again we don't have any decisions yet, I thought it would be more useful to use this week to talk about the student speech rights cases in brief of the past, to give a brief overview of how this speech case will fit in to those cases, to give some background for whatever the opinion is, because it's interesting. It's very interesting. That's not for comedic effect. That's because last time I did this, I lost my voice. So, I'm not going to take you all the way back to free speech days of past, just because I don't want to bore you to death, and also because I think I would never be able to get in depth enough to each of the cases to really provide any sort of meaningful takeaway in a short YouTube video. I think they each could be their own video. So I'm just going to go through the ones briefly that I think matter when it comes to this case. But first, the First Amendment. So the First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and to petition the government for redress of grievances. Okay, so this is the clause on which all of these cases are based. So the first case that matters, I think, relevant to this case, is Tinker v. Des Moines. If you're interested in reading more about this, this is a great book. It's called The Struggle for Student Rights, Tinker v. Des Moines, and the 1960s. It talks about this case at length, if you're interested in this case. But basically, students wore black armbands to school in protest of the Vietnam War and were suspended. This established the Tinker test. So as a result of this case, this is the high watermark of free speech for students. So everything else is just cutting it back, but this is the high watermark. But unless there has been exceptions made, this is the standard that holds to this day. So, quote, student speech is protected so long as it does not materially and substantially interfere with the requirements of an appropriate discipline in the operation of schools, end quote, and does not conflict, quote, with the rights of others to be secure and let alone, end quote. So it's protected unless it materially and substantially interferes with schools, like the operation of schools, or when it conflicts with the rights of others to be secure and let alone. So, like harassment. That is basically saying, yeah, students have speech rights and they don't just leave them at the schoolhouse gate. That's the big quote that everyone quotes from this case. In fact, this book, which is referenced many times in the articles I read about this case, is called The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. An excellent book by Driver. One of the chapters in here is about speech, not all of them, but it's an excellent book if you're interested in the relationship between the Supreme Court and education. So that's the high water mark. Now, what exceptions might this case, if it happened in school, fall under? One could argue that Frazier v. Bethel may apply because the F word was used. Lewd speech in this case was ruled to be unprotected. But he was using a series of innuendos in a speech at school in support of his friend who was running for student government. I don't really think it applies because that's not how the word is being used in this case. But again, and it's also not in school. So I'm just saying what could be brought up. However, one of their goals from that case in education was teaching, quote, the shared values of a civilized school order, end quote, was encompassed in the, quote, basic educational mission of schools, end quote. So this is where we start getting this teaching kids to be civil. Lewd speech isn't civil, so therefore there's a pedagogical imperative to not protect that type of speech. And this carries over into other cases as well. The Hazelwood v. Kuhlmeyer ruling left unprotected all speech that could perhaps bear the school's imprimatur. This case, it doesn't apply. So far we've got like the Tinker test and maybe lewd speech if you really stretch it. But maybe the idea of like teaching civility, maybe. It's in the Frazier v. Bethel case as well that the argument for punishing like curse words is okay if you do it all the time. According to district courts who've interpreted Frazier, and most schools do prevent, you from swearing in school. But are you never allowed to swear then outside of school? Are you never allowed to talk negatively about the school? Because it could bring a negative energy to the school. It just really raises questions about students' ability to advocate for themselves. And people may not think that's important, but students have actually successfully advocated for a lot of important developments in education. For example, a student walkout in Philadelphia was one of the largest examples of student protest where they won major victories for the creation of Black Studies courses during the Civil Rights era. It was one of the largest protests at that time. And the Philadelphia Student Union continues to be a strong advocate for student speech rights. So if you aren't allowed to say negative things about schools, what does that mean for the Philadelphia Student Union? Because now their speech can be, and they have an online website that you can see their views on. What does that say about their ability to talk negatively about schools in the language they deem appropriate? And that could be, in harsh terms. I haven't seen any of that on their website. They're a very professional group of students, but it isn't unrealistic to think that they might interview somebody, a student, who has some harsh words for the lack of just funding and care for Philadelphia schools and their facilities, and just the abysmal conditions of even just the buildings in Philadelphia. So I just worry. It's just concerning to see that we might have this major break from Tinker. Because clearly Tinker doesn't apply. Maybe Fraser applies if it happened in school, but it didn't. This is just talking to your friends. Yeah, it's a lot of friends. But if you had like a big party, back in the 80s, and you got on a mic and you were just like talking about the school or whatever as the boombox plays, I mean, do you think the school should have just like, oh, well, for your speech here, you're off the team. You're off the team. Now, it should be noted that the first court ruled in favor of the student, and she was reinstated and went on to be in the varsity team her senior year. So that's cool. And it wasn't that big of a deal. So clearly there was no like big, risk of substantive disruption to the school day. Regardless, it won't matter because the Supreme Court will ultimately decide this case. It's going to be very interesting to see what the rulings are. The last case would be Frederick v. Morris, or better known as Bong Hits for Jesus. There are a few justices on the court still from that case, but they ruled against the student. So that's not that promising, because again, that was a student who was not in school that day, but did go across the street from the school to hold the sign where he knew students would see it. And it was deemed unprotected because it was promoting the use of marijuana rather than the legalization of marijuana. That was the deciding factor. Alito was the deciding vote there. So that's already like that kind of applies because it's not really at school. It's kind of at school, but it's not really at school. But it's during the school day in front of the school, in front of teachers. I don't know. I just think that if they rule in favor of this school district, I don't know what speech rights students are going to have. Um, if you're interested in learning more about Supreme Court cases of the past, and you'd like to see me talk about any of those cases more in depth, leave that in the comments down below. If you are looking for resources so you can read about it, you don't have to hear about it from me, I highly recommend this book, Lessons in Censorship by Catherine Ross. As you can see, I have read this many times. I reference it often. The best part about this book, hold on. Okay, one of the best takeaways, though, from this book is an identification of when you can silence student speech. As of right now, it's all going to change potentially, but as of right now, at 1 a.m. on April 30th, this is the breakdown for when you can punish student speech. So first, you identify the type of speech. Pure, the student's own speech. School-sponsored, appears to be the school speech. Or unprotected, which would include lewd, pro-drug, threatening, inciting violence, or defamatory. Okay, those are your three categories. Now, if you go with it's lewd, but bear in mind this is at the school, you could censor or punish unless the pro-drug speech is political, but it's not about drugs. So if it happened at school, this would be a punishable speech. You couldn't just swear at school about F this, F that, F everybody, bleh. You know, you would get in trouble. However, this was not at school. Big notice here, not at school. Pure speech is a student's own speech, which you cannot silence. It's clearly not school-sponsored speech. I'm just going to skip that. So then it could be pure speech, which I would argue that it is, especially because it's not at school. And you are not allowed to censor pure speech unless you reasonably anticipate material disruption or speech collides with the legal rights of others. So like the not being harassed thing. It does not meet either of those. If my understanding, and we'll see what the opinion says, but this would be my guess. If the opinion rules in favor of the student, this is going to continue to be the framework, with maybe a caveat about sometimes when you could censor speech, but I really doubt they're going to try and illuminate all those things, but maybe they will. Maybe they'll leave the door kind of open and there'll be a fourth option here. Or, if they rule in favor of the student, they'll just leave it like this and say online speech meets the pure speech standards. It should be met by the Tinker standards. I think that's still kind of ridiculous, but less ridiculous than any other alternative. So that would be kind of ruling in favor, kind of ruling against, but if we're going to put it somewhere, let's put it in the pure speech section. If they rule against the student, is this whole framework going to now be the standard for all speech by students in and out of school? Because That's insane. We'll see what happens. We'll see what happens. Because if this becomes, this is a personal, I mean, in addition to this being like one of what I see as the most important Supreme Court cases in education for years, in years, I'm gonna have to rewrite my freaking thesis. Because it's just all gonna be outdated. Crazy. Anyhow, so that wraps up Free Speech Friday news for this past week. Next week, we will definitely be talking about this case again. Again, if you want to a deep dive into any of the Supreme Court cases I mentioned, or a federal district court decision that I did not mention that you find interesting, leave it in the comments down below. And if you want to see more content like this, click subscribe and ding the bell button to know when we post, which is every day, but free speech topics are just on Fridays. Most importantly, though, I hope you have a wonderful day, and I'm very interested to see what you think the ruling of the Supreme Court case should be in the comments. Again, I'm leaving all of my references, including the book's title and author, and the articles I'm referencing in the description of the video, so you can look for them there. I'll see you next time. Bye!